Good afternoon. All right. So today we're going to begin looking at how our professional relationships are affected by our professional obligations. But before that, we're going to, as always, begin with our practice MPRE questions. So this one is the one that's comforting for those of you who are looking at possibly being at the bottom of the class. So the attorney in question is unaware that their grade in their 1L year was much higher than it should have been, and they, in fact, should have failed out. Okay, maybe this is less comforting than I thought it was. So you're putting the attorney in question, putting a reasonable amount of time into their preparation, put in normal effort, but they are just not able to operate up to the same standard of their colleagues, and just not aware of how the law works, recent developments. You know, the trying is there, but the outcome is not. Could the attorney be subject to discipline for incompetent representation? And here are your answer choices. So take a second. Oh, and these questions are on D2L if you need them. So sorry. I remembered to upload them today. Give you guys a few more seconds. Oh, that explains why that's not working. Okay, so just to show you guys, right? So the vast majority of you think that the correct answer is B, that this attorney is incompetent. There's a small group of you who say that, in fact, he can be disciplined for being incompetent because he never should have graduated from law school. And then smaller groups that think that this is not discipline worthy. And so the answer is that B is correct, right? So most of you were correct because the Rule 1.1 measure is objective. Either you are competent or you are not. You know, how much you're trying, whether you intend to mess up, doesn't matter. If you are incompetent, you are incompetent. And part of the reason why, for those of you who said A, right, the duty to measure competence does not lie with the law school. It lies with you. So you are responsible for determining if you are, in fact, competent. Good luck. Hopefully you will know enough to be able to handle that. Okay. So next question, right? We have highly knowledgeable and skillful, but, okay, this question's about me. But he lost every case that he undertook, or because he was an unattractive person, definitely about me. Takes on unpopular clients, all sorts of parade of horribles happen to the attorney's clients. Could the attorney be subject to discipline for lack of competence because he is consistently losing every time? And so here are your answer choices. So, and give me 1 second. And take it away. few more seconds. Okay, so looks like 2 of you think that discipline is avoidable because things could have gone worse. And 2 of you think that competence also involves like choosing cases where you're not going to lose all the time. The rest of you think that, you know, as long as you're doing the work and know your stuff, like, you're fine. So the vast majority of you are correct, right? This is sort of the flip side of the last question, right? If you are competent, it does not matter that you are losing, okay? Thank goodness. And so hopefully, like you guys, those of you who said B and C, I hope you were trolling me, particularly if you said B, because like I understand the logic that might lead you to that, but it's troubling about, it says troubling things about like access to justice principles. If you think that like representation should depend on your resources or on whether or not you are in the right as a matter of law. So that these are the logic that leads you to be is sort of inconsistent with the values that we want you to espouse sort of once you graduate from here. Okay. Next, last one for today. So this is this one is about all of my opposing counsels. So very winsome, likable attorney, utterly pants in terms of providing representation, but gets lucky, right? Can he be subject to discipline for lack of competence? And here are your answer choices, and take it away. Give you a few more seconds. Okay. All right. So, vast majority of you think that incompetent lawyers who win are still incompetent. Looks like 2 of you think that winning proves that you are competent. And then 1 of you thinks that, like, it's not fair to me if bad lawyers can beat me. And 1 of you thinks that, you know, you got what you came for, and so what are you complaining about, right? So vast majority of you are correct because, again, right, competence and outcomes, separate things, okay? So for the person who said B, right, remember, even if everybody is competent, somebody has to lose. And the person who said D, what I'm going to tell you is that, like, with the exception of waivable conflicts, an answer on the MPRE that suggests that the contract defines the ethical responsibilities of the lawyer is always going to be wrong. Okay? For the two of you who said C, right, as a practical matter, you're right. No one files ethics charges against the lawyer who won. At least not competence charges. But the rule sort of exists independent of whether charges are filed. Okay? So, questions about today's questions? Okay? So, now let's talk about the reporting process and sort of your relationships to other folks in your professional life. So, Mr. Metz, what is the effect on your reporting obligation that when we refer to knowingly in Rule 8.3a, we treat that as an objective knowingly rather than a subjective one?
That means they don't look to see whether you actually knew in your actual mind whether a reasonable person knew or should have known.
Exactly right. And as a practical matter, in terms of whether you are subject to discipline or not, what is this objective standard intended to defeat?
People who intentionally look the other way.
Right. Exactly right. Now, I will give you a caveat. Everything that Mr. Mitz has said is correct. But there is one caveat, which is that there is a subjective approach to this rule that can bite you. And that is if you accuse another lawyer of misconduct, but don't report them, then in Kansas, and I will tell you, in most states, not all of them, but most of them, this is a Rule 8.3a violation. Because you acted as if you knew of an attorney's misconduct, but you did not report it. Okay? So, don't go to opposing counsel and say, you've broken the rules of professional conduct by doing X, Y, and Z. If you don't settle this case with me, I'm going to report you. No, that's not how it works. If you think they broke the rules of professional conduct, you report them. Here endeth the reading. Okay? All right. Thank you, Mr. Metz. Mr. Braun, so you become aware of some sort of alleged misconduct. You report as you are obligated to do so under Rule 8.3a. Bar counsel does whatever investigation they're going to do, refer the matter to the committee. The committee, after reviewing the file, dismisses the charge as unmerited. Then you are served with a defamation complaint by the attorney you reported. What is the result?
I don't think the defamation complaint would have much merit to it unless it was like a totally frivolous, like almost like harassment type thing.
Say more about that. I'm not sure that you're wrong, but like say more. Explain it.
I guess it was just like a BS report, then I think you could. I don't know if you'd be liable for defamation, like something that far, but maybe there's a different kind of ethical rule that you violated.
I mean, maybe. That's not what the question asks, right? The question asks about defamation. So, here's what I'll tell you, right? Here's what I'll tell you. If on an exam I ask you what's the result of the defamation complaint, and you tell me about a separate ethical violation that the attorney in question may have committed, you have not answered the question, and you will be scored accordingly. So, like, what's the result? I think you're on the right track. That like the defamation isn't going to go anywhere. Do you know why? It's okay if you don't, because this is a little sort of beyond the scope of the class.
I guess the other attorney would have to prove it's false.
I mean, so under normal circumstances, that's correct. However, this is a little bit of an odd duck, right? So there's a wrinkle in defamation law called a qualified privilege. So even if the statement is defamatory, even if it's false, statements that you make as part of a regulatory process are protected from defamation liability. And I sort of bring this up for you to reassure you that you're not going to be retaliated against if you're reporting things that people do in good faith, right? So sometimes young attorneys are like, well, you know, what is this person going to do to me if I report them? And the answer is, who cares? You know, they can't sue you. Well, they can sue you, but they will lose. And, you know, anything else that they do can be managed, right? What I will say is that, like, the qualified privilege is not absolute, right? That's why it's called qualified. So the statements that you make to the committee are privileged, but, like, if you then turn around and repeat those statements, say, to the media or to clients of the attorney that you've reported, then the privilege does not attach, and you may find yourself facing down a defamation lawsuit, right? So report where you think reporting is warranted, and then shut up. Okay? All right. Questions? Thank you, Mr. Braun. I appreciate your helping me with this, because this one was a little sort of out of left field. Okay. Mr. Guest, let us suppose that you know an attorney. Hopefully soon that will be the case. Let us suppose that the attorney that you know dies. Hopefully that will not be the case very soon. Let us suppose that you become or are aware of some sort of misconduct committed by the now dead attorney. What are your obligations under the rules?
So based on my understanding of the rules, unless you're supervising them, you're not accountable for them, or am I reading the wrong spot here?
So our reporting obligation only extends to lawyers we're supervising?
No, I'm going to take back what I just said.
Okay, fair enough.
My understanding, I can't pinpoint the exact word, but my understanding is that you would have a responsibility to report violations of ethics that you are aware of as an attorney.
Okay.
That's an obligation that you sign on to if you become an attorney.
Right, so that's Rule 8.3a. Okay. Let me ask you this, right? So the problem in the casebook, right, actually the problem that it shows you is about an attorney who sort of like confesses their misconduct and then dies, and then you, as the confessor, learn which case is involved in, like, which case had the misconduct occur in it. But I want to, like, twist the question just a little bit and ask, you know, if you find out about the misconduct after they've died, do you still have to report?
So after the attorney died?
Yeah, after the attorney died. After the attorney died. We'll get to what happens after the defendant was executed in a minute.
Based on the facts of this specific fact pattern,
Okay.
I would absolutely report it and spare no effort to correct the record.
Why?
Someone's life is on the line. An innocent person's life, but second to that, a human life is on the line.
I mean, fair enough, right? Okay, so I get what you're saying. Do the rules require you to do that?
Not to my knowledge.
Okay, why not?
Well, your colleague's no longer an attorney.
Yeah, so that's sort of, you've nailed it right on the head, right? What is that the issue here is, like, the rule doesn't seem to limit its scope to living lawyers, but I don't know if a dead person is in fact still a lawyer. Like, but I tend to agree with you that, like, applying the reporting obligation to the misconduct of dead lawyers, is mostly a good thing. So Mr. Guest has taken the position that, regardless of what the rules require, right? Because the obligation to report does not limit your ability to report. So even if you are not obligated to report the misconduct because the dead aren't lawyers, you may still be permitted to report it. Okay? But I want to get to. Sorry, I just looked at this and realized I put my slides in a different order than what I'm talking about. So I'm going to put the permissive reporting. I'm going to put a pin in that for just a second. So, Mr. Guest, does your answer change if the defendant has already been executed?
It's still fact specific to the pattern, but
Sure.
But yes, in short, assuming that, let's say the defendant's been executed and there's no other sort of source of relief for the family or any kind of thing like that, if it's totally settled, then it sort of seems moot to report.
I mean, I think I also come down kind of in that space as well. Like, if reporting changes something, then absolutely reporting seems to be, salutary at least. I could see sort of coming down on a harmless error space if there's nothing that can be done to correct the issue. Not to suggest that the wrongful execution of an innocent person is harmless, but that once done, it cannot be taken back. So,
What about the family? Like, I would want to know if my father was not a murderer, if he had just been executed. Like, I don't.
yeah.
There has to be some remedy for that.
I mean, does there?
Huh?
Does there?
Should be.
Okay. Should, yeah. Maybe, right? But is it required?
To report it?
For there to be a remedy for that?
Absolutely not.
Yeah, right. So we could go on for quite a while talking about, like, all of the ways in which the legal system sort of condones substantive injustice. I could give you several examples from my own practice, thinking back to all of the cases that I handled competently that I lost. But as far as, like, whether you should report under these circumstances, right? Okay, maybe, right? Let's look at maybe a less stark example, right? So we're not dealing with a wrongful execution anymore. We're dealing with now a money judgment, right? So dollars, against a corporation that has gone bankrupt and liquidated itself, and just, like, ceased to exist, can be as a result of the judgment. It can be as a result of, like, other mismanagement on top of the judgment, whatever. There's nothing there to get anymore. And for those of you who've had bankruptcy, let me just go ahead and, like, close another door. We are past the clawback period, so the trustee can't go and find assets and bring them back. But the judgment exists, and it turns out it was secured through misconduct. Should you report? Ms. Coolidge, should you report under these circumstances? So the key piece of it, right, is there's a money judgment. It was secured through misconduct, and there's no way to get back the assets that either to satisfy the judgment or to claw back what was paid.
I guess what's stuck in my head is like you still should report, I guess, especially if they're still, but they're dead, right?
The lawyer's dead.
I guess I see you have to report in case there are cases where there could be judgment possible. I guess if you wanted to prove that he was incompetent and there is a case out there that can have proper.
Okay, so well, I mean, we're going like misconduct encompasses more than incompetence, but yeah, you're right. Yeah, so the reporting obligation may not change anything for the case that the misconduct connects to, but it may trigger investigations into other cases where maybe there is relief that could be ordered. Okay, reasonable approach. Maybe there's no such thing as harmless error given that situation. I can tell you that not so much in the disciplinary process where like courts do sort of consider patterns, but absolutely in the like substantive relief, that's going to be a hard sell. You may get a lot of like, well, okay, maybe there was misconduct by the attorney, but whatever, right? I mean, it sounds like you guys are sort of leaning towards you report the misconduct sort of regardless of what the broader circumstances might be. And I mean, there's a flavor of like kill them all, God will know his own attached to that. But like I get it. The one thing that I would point out to you is like the legal community is not huge, and like particularly if you're practicing like in a small town somewhere, it's going to be very small. You're probably all going to know each other, and like, you know, what will you say when the lawyer's spouse finds you in the grocery store and is like, why did you do that to my spouse? Right? What are you going to say? I don't know.
Do the crime, do the time.
All right. Well, if you say so, I suppose, right? We'll take Mr. Guest off all the Christmas card lists. No, I mean, I think that's a perfectly reasonable response. Like, you should recognize that like there may be social consequences to taking that stance, right? Right? Any questions about this? Okay. All right. So, like, for now, Rule 5.1 is not super relevant for you guys, except to the extent that it appears on the exam. But I have noticed this difference, right? Under Rule 8.3a, the objective standard for knowing is intended to expand the scope of the rule, right? As Mr. Metz points out, it's to ensure that we can discipline those who are willfully blind to misconduct. However, the objective standard for supervision under Rule 5.1a and 5.1b limits the scope of the rule. So instead of saying that, you know, the supervision requires you to reasonably know what your subordinates are doing, instead you are required to make a reasonable effort to ensure that your subordinates are behaving ethically. So, Ms. Bueller, why the difference?
I was saying just along the lines of maybe because you're directly responsible for the people you're supervising, unlike lawyers at large are not directly responsible for another lawyer and the students.
Well, I mean, it seems to me that that would justify more scrutiny, right? That like, it's not if I am required to reasonably know what, you know, random knucklehead lawyer does, like how much more so is that true for lawyers that I am directly supervising, right? But in fact, the rule imposes a lower standard where all I have to do is make a reasonable effort to know what they're doing, right? So why is there a difference? Ms. Solomon, can you help us out?
Does it have to do with like, to me, like 5.1 A and B kind of almost seems preventative almost, like they should be making reasonable efforts by having all of these, you know, systems in place or whatever, but 8.3 is more of a reactive thing, so it's kind of more you see the misconduct, then you have to report. That's kind of what my thought is.
That seems reasonable. Let's see if we can unpack some other things. Mr. Henninger, anything? Yeah.
Yeah, is it just I guess encourage these kind of more experienced attorneys to take on younger?
Well, I guess, you know, if the rule is intended to encourage certain behaviors, wouldn't it say should rather than shall? Right? So shall is a mandatory term in law, right? You shall do something. You know, if we see a regulation that says you should or you may, that seems permissive, right? So if the purpose is to encourage something, that seems like a permissive requirement. It's not a term that makes a whole lot of sense. But I think that's, you know, I think that's something, you know, I think that's on an interesting track of like, who is the rule pointed at, right? Yes, Mr. Toy.
Is it maybe that these similar standards have opposite effects on the rule because in a general population, you're not really expected to know everything that's going on with your attorneys, but in a supervisory role, maybe you are assumed to know more, and so this objective standard actually works as a limitation because it confines what you know to something that's like reasonable for you to know instead of people just assuming that, oh, well, since you're a supervisor, you should know.
Okay, but then why would we want to do that?
So that you're not holding a supervising attorney liable for any and every conduct that they're doing.
I mean, I think that's right, but like, why is that desirable?
So that you have people still wanting to be supervisory attorneys.
I mean, supervisory attorneys make money.
Yeah, but it's not going to matter if they're getting sued for malpractice or being held liable for all this stuff, getting this stuff on the record.
I mean, they also have the power to define the conditions of their subordinates' employment, so they have the ability to be as strict as the rules require, however strict that is, right? So let me ask you this, right? What is the fundamental source of all rules? I'll give you a hint. I've said it in this class. Who makes up the rules?
Who makes up the rules?
Yeah.
These rules, the law rules?
I mean, the rules of professional conduct or rules in general. The bar? I'm sorry, yes, Ms. Burton.
I
Yeah.
People with power want to maintain power.
Yeah. Rules are an exercise of power, which means that what rules forbid and what rules allow reflects the interests of those who have the power to make rules. So, I will admit, I'm not fully convinced by that argument. And the reason I am not fully convinced is that, we do not yet have a panopticon in the practice of law, despite the best efforts of my case. And if you want to see sort of how that plays out, you can Google above the law and check you email for a story, I guess it's about 10 years old at this point, about a partner who was very unhappy that he could not surveil his associates 24/7, 365. So it seems to me that applying the Rule 8.3 standard, as Mr. Hoy said, right, and I wanted us to get to that cynical answer before we sort of jumped ahead to what I think is the right answer. But if we applied the Rule 8.3 standard, then the approach to Rule 5.1 would require supervising attorneys. First of all, the burden would be on the supervising attorney to show that there was no reasonable way that they could have discovered misconduct by their subordinates. So, because of the reasonable effort rule that we have under Rule 5.1, if you meet the requirements of a reasonable effort, and the commentary to the rule gives you more or less what the committees are looking for, as long as you meet that standard, doesn't matter whether you knew or not. Putting forth the reasonable effort gets you there. Okay? All right. So questions about the supervisory rule, both in terms of its obligation and in terms of the safe harbor. Okay, so let's see. Mr. Albertini, so I want to talk to you about the subordinate safe harbor in 5.2b, right? So if you are directed to do something, and then later on it turns out that that thing was unethical, as long as the directive involves a reasonable resolution of an arguable question of professional duty, you are safe, right? Your supervisor takes the hit because they're the one who decided to do the unethical thing. But how do we know if a question is arguable and whether the resolution is reasonable?
You should probably either ask other attorneys in the firm or do independent research on your own.
Yeah, unfortunately, there's not really an easy sort of clear rule for us to apply here. The situation is really just if you are directed to do something and it smells funny to you, then you're going to have to do some research. Either you're going to have to do your own research or you're going to have to talk to some other folks, right? And Mr. Albertini says, speak to other lawyers in your firm. I think as you see from the readings, right, that is not always going to be helpful because sometimes the senior lawyers in the firm are sort of all in it together. But if you go outside the firm's walls, you do have to be careful not to breach Rule 1.6. And we'll talk about that when we talk about Rule 1.6. There is an exception to that rule, 1.6b5, related to obtaining advice on legal ethics. So you'll have to, we'll talk about that when we get there. Okay? So thank you, Mr. Albertini. Ms. Hausholter, presumably you have all gotten jobs during your summers here at Washburn. Ms. Householder, can you be disciplined for something that you do or are ordered to do during your summer job or jobs?
Yeah, absolutely. Like in the military, that I'm just following orders, excuse doesn't work.
So, I would like to.
There are caveats with that, if that's what you're
All right. Give me the caveats.
So that would have the language that if the supervisor directed the action, the subordinate learner may be able to prove that they did that action.
Okay, let me stop you right there. Are you a lawyer?
No.
So does that rule apply to you?
I feel like you're still serving though, like in a part of the legal profession as a legal intern, so you still need.
What's the definition of lawyer under the rules? Definitions, I believe, are 1.0, maybe 1.1. No, 1.1 is competent, sorry. But there is a definitions rule. So how do the rules define lawyer?
Can I defer to someone else?
Absolutely, yeah. So let's, Mr. Harriman, how do the rules define lawyer? No, it's fine. What? I heard something? What? I heard you say something.
Graduated law school is what I was thinking.
Yeah. Lawyers are people who have been admitted to the bar to practice. And so you guys are not lawyers. In general, there is one ethics rule that applies to law students, and that's Rule 8.1. However, Ms. Householder, and here's where I think you are correct, is that I've never seen a rule that allows third-year law students to practice under supervision that does not say, by practicing under this rule, you agree to be bound by the rules of professional conduct. That doesn't mean that there aren't states out there that don't do that, but I've never seen one that didn't. Okay? So that may be where you're correct, Ms. Householder, is that third-year students operating under a third-year practice rule are treated as lawyers for the purposes of the rules of professional conduct. And of course, right, Ms. Householder, the other way in which you're correct is that regardless of whether you're subject to the rules in your summer job, anything that the committee finds out about something you did at your summer job can absolutely become like fodder for them and could delay or prevent your admission, right? So for example, if you are a summer associate who does something that winds up on above the law, which I don't think happens much anymore because they all know that they'll wind up there, then like the committee might have something to say about that. Okay. Thank you, Ms. Householder. Thank you, Mr. Herman. Mr. Balthazar, so if you are directed to conduct a hearing that you have never done before, how much prep time would you want?
A lot.
Put a number on it if you can. I mean, I agree with you. A lot is correct, but put a number on it if you can.
I don't know where to start that, but probably at least
Okay. Now, like, so that's how much you would want, right? What's the bare minimum that you would need to, like, barely clear the rule? And remember, right, you can be competent, think back to our practice questions, right? Competence is not a super high bar, and it does not require positive outcomes. So what's the bare minimum prep time that you need to reach competence? Not confidence, competence.
It would probably depend on the type of hearing.
I mean, fair enough, right? But let's assume that it's the kind where, to be confident, you want about a week. So what's your bare minimum for that kind of hearing, whatever it is?
I probably want like
Okay, fair enough, right? We're going to come back to this last question. When I was, about where you guys were in terms of experience, right? I kind of felt the same way that you do. If I had less than a week to prepare for a hearing, I was like, I don't know about this. So this story here at the bottom, I was working remotely for a firm that was about 3 hours away from where I lived. They wanted to see me for a couple of days a week, and then the rest of the time I was working from home. And so I drove in Tuesday morning, arrived early in the afternoon on Tuesday, was told, oh, hey, there's a hearing tomorrow. I need you to write and file a brief on it. And then, about 9 o'clock Wednesday night, I was told, oh, by the way, you're going to be arguing that motion tomorrow, right? Worst fitting suit I've ever worn in my life because it belonged to my boss. Hazing happens. We'd like to pretend it doesn't, but it does. Okay. So, thank you, Mr. Balthazar. Mr. Huerger, I want to come now back to this last question on this slide, which is, the problem in the casebook talks about the time and the resource cost of being competent in this practice area is greater than the fees that can be charged to the client base. And so what should we do in those kinds of practice areas?
I would say either try to get competent real quick or find somebody else that would be more capable of representing that client.
So what would make someone more capable of representing that client?
That's the field that they're an expert in or the field that they regularly practice in.
I mean, but like the way that the problem is phrased, right? Think back. Solomon Hellman is like, oh yeah, right? I have 1,500 active files. I do this kind of immigration stuff all day, every day, and I do not have the time or the resources to provide competent representation to all of these clients. Because if I did invest that time and those resources, my fees would be so high that none of them could afford to hire me. So, this is an expert in that field saying competence is impossible. What now? I think I'm watching you sort of go, and I get that. Let's be creative. So throw it out to everybody, right? What do we do with the practice areas where competence is uneconomically feasible? Is Morrissey?
I think in situations like that is where you need a lot more legislative funding for those type of areas of practice.
So vastly ramp up legal aid.
Oh yeah.
Okay. Now I'm going to transplant you into Nebraska, and the legislature is going to tell you to pound sand. What now? Because I think that's a viable solution if you have a legislature who gets on board with it. Now I'm taking that away from you and saying, what now? Mr. Metz.
I guess if you're a lawyer and your focus is to make money, then don't go into a practice area that doesn't make a lot of money and be surprised when it doesn't.
Right, so we're going to eliminate this practice area as one that lawyers enter into just through sort of market forces.
I bet there are people out here who would do it that, just out of the goodness of their heart.
And so how many bills does the goodness of your heart pay? I can tell you none. I think that's I think that is kind of where we are as a profession. That seems to be kind of what we're drifting into. is that we are, sort of rendering it impossible to engage in certain practice areas as private attorneys, right? We're sort of ceding the field to nonprofits and charities with exactly the problem that we identified with Ms. Morrissey of like, there's always more demand than there is resources to meet it. And so, Mr. Hill, you had your hand raised.
Oh, are you talking about like the right to counsel? Like this is not a constitutional.
No, we're just talking about like, these are folks who need a lawyer, but because of the economics of the practice area, private lawyers cannot provide competent representation. And probably neither can nonprofit and charitable employees, right? Because they're always going to have, a caseload much like Solomon Hellman's, right? Because they're always going to be willing, doing it out of the goodness of their heart, they're always willing to take on more than they probably should. So what do we do? Yes, Mr. Guest.
Structural reform. It's a problem that's intractable and inherent to allocating, legal representation.
I mean,
powers of the free market.
That
Without structural reform, it's an unsolvable problem.
what structural reform would you suggest?
Sweeping and fundamental structural reform away. In order to solve this problem specifically.
All right, Elizabeth Warren.
It's a system that allocates resources in such a specific way that the free market dictates. And if the free market dictates that resources cannot be allocated in such a way, they won't be. We can sort of try to patch things up with charities and legal aid, but so long as this is how we as long as this is how billing works, this is how the private sort of legal practice works, the problem is just there. It doesn't.
Yeah. I think you're onto something, but like I kind of, when I said what kind of structural reform, like I get what you're saying about like big sweeping change. Sure. Like,
You want me to be specific?
yeah, what do you want to do?
Nationalize the legal industry?
All right. Okay. All right, Clement Attlee. No. I think that is like, given the assumptions that you've stated, right? I think that's a reasonable response, right? Let us assume that we are not ready for the glorious revolution. What else can we do to solve this problem? Is there anything? Yes, Mr. Monk. So all that does is like, that is sort of a case-by-case thing. In immigration, so I actually, I will tell you this, I sat on a prize committee for doctoral dissertations last year, and the winning dissertation, one of the things that they found, they were interviewing immigration lawyers on both the defense and government side. One of the things that this scholar found was that lawyers representing immigrants absolutely play the time game, basically to give their clients more time in the United States. So like they absolutely drag their cases out, because if you know your client's going to get deported, but they can't get deported until the case is over, the longer the case goes, the longer they get to stay. And there are benefits associated with that. So you're absolutely right that one of the things we can do is we can case by case sort of like drag things out as long as possible, so that so that we're not dealing with so much simultaneously. But I think all that does is like take the problem and kind of like smear it over a bigger time frame, right? So yeah, Mr. Metz.
Could you require pro bono hours from everybody who's a lawyer?
Some bars do that. Doesn't appear to be making a difference. It's reasonable to sort of like, see if we can tug on that. Ms. Wilbur?
I have a question and then
Okay.
My question is what are the practice areas where this, besides immigration, what are the other areas where this is going to be?
I am hesitant to like call names because like some of you might be planning to go into those practice areas. So I think in general, if you are dealing with clients who are low resourced, then it is very likely that you will be unable to draw enough from them in fees to make the exertion of time and resources worthwhile. So that is generally my my stance, with the exception of areas of practice where you are entitled to pursue contingency fees, because then what's happening is actually the defendant is the one paying you. But sort of beyond that kind of like broad strokes, I'm not comfortable sort of giving you like, well, if you go into bankruptcy, I don't know.
Okay, so my idea is like kind of what the teachers did with the teacher shortage, where they're specialized. They do a waiver, but I'm not suggesting a waiver here, but kind of where it's more like certification just in that very specific niche area where it's not 3 years of law school, maybe it's just 1 year of law school, where that's the focus, and that's all you get is just that.
So I think you're onto something, right? So when you are a baby lawyer at your first real lawyer job, who is going to be telling you how things work? Let me phrase it differently. Mr. Hill, were you enlisted or were you commissioned? When a new butter bar showed up at your unit, did they know a damn thing? New butter bar, fresh out of the point.
Well, I was on a submarine.
Okay.
Go through a year and a half of submarine school. You get to the sub, so yeah.
Yeah? So didn't know culture. So didn't know how things were done. They knew how to perform tasks, but they didn't know like who to ask, and they didn't necessarily know, like, they might know where the wardroom is because all the subs are the same. So what role did the Chiefs play? Not the Kansas City Chiefs.
Chiefs are just like senior men.
Yeah?
Yeah.
So in a law firm, who do you think are the chief petty officers? Fair enough, right? So anyway, where I'm going with this, where Mr. Hill and I are going with this, is that it is a almost universal truth, maybe not in submarines, that brand new officers in the military are stupid. And they have authority, but no understanding. And the folks who keep them in line, if they're smart, are the senior enlisted, right? Chief petty officers in the Navy, senior sergeants in the Army, etc. In a law firm, and I'm not suggesting that a law firm is like a military unit, but in a law firm, the people who know what's going on are the paralegals. They are the ones who will make or break you as a young lawyer. As a young lawyer, you are a brand new second lieutenant, and you have complete authority and absolutely no understanding. Okay? So where I'm going with this is, as Ms. Wilbur points out, it is possible to open up certain areas of practice to paraprofessionals. In some states, this is already happening. So in some states, paralegals can represent clients in things like administrative hearings. And in some states, they may even be eligible to engage in appearing in certain courts. So the one thing that I was looking for that you guys didn't get to was differential billing. And this is actually probably how most successful immigration firms do it. So they charge absolutely out the ear for things like investor visas or student visas or work visas, and then asylum clients, refugee clients, contesting removal clients, those folks are on a pay-what-you-can plan. And then several of you sort of nibbled around the edges of this last option of, well, we just sort of have to deal with this. So, Mr. Hill, thank you. I didn't mean to pick on you there, but I appreciate your good humor on it. So, all right. But I have a follow-up to this question. Ms. Sims, if I tell you that having a lawyer at an asylum hearing, sort of, even if the lawyer does nothing, increases the chances of asylum being granted by 55%, do we still care as much about what's happening to Pat Conway? That's the lawyer in the problem, right? The new lawyer who feels like they're incompetent in immigration court.
I mean, yeah, I would say that we still care.
Why?
You want your legal representation competent.
But if it doesn't matter, who cares?
Something might happen where it does matter, and they need to be competent.
Yeah, right. So I agree, pretty much, right? So when competence matters, it matters a lot, right? So just one example from immigration, right? A major immigration and criminal procedure case in the last 10 years involved a criminal defense attorney who advised their immigrant client to take a plea on a charge, right? And it was a good plea deal, right? It was a felony charge, and it was pled down to a minor misdemeanor, and we're going from looking at several years in prison to a fine. But what the defense lawyer failed to do was advise their client that any criminal conviction is grounds for removal. And it was held that this constituted constitutionally ineffective assistance of counsel, that you are required to know enough about the consequences of what you advise your client on that you can tell them what those consequences will be, right? So, for better or worse, that's what we have, right? Okay, let's see. Mr. Johnson, so I told my boss about something that my fellow associate did, right? And now I'm being fired. This is probably like a question from Suits, right? This is a Harold Guntherson question. Is that legal?
Probably not in most states.
Why not?
You're retaliating against them for something that they have an obligation to do.
So this is essentially what the Weider Court says in 1992, right? That the duty to report preempts a duty of loyalty that you have to your employer. And for those of you who've had employment or who are having employment discrimination, I will tell you that I read the Weider standard as looking more like a but-for standard rather than a motivated by standard. And what that means, speaking as a plaintiff's employment lawyer, is that I'm not sure that Weider gives you any practical protection. Basically, proving that but-for standard is not quite impossible, but it's close, right? So in Kansas, we don't have the Weider standard, but we do have a case that says, oh yeah, Weider, that's good, right? So, all right. Thank you, Mr. Johnson. Ms. Carr. Ms. Carr, you have this case from the Kansas Court of Appeals that I just told you about, McCurdy. It says that as an attorney, you're entitled to exercise independent professional judgment. And McCurdy involved a lawyer who worked for the state. So there's a civil service statute, and it violates that civil service statute to force you to subordinate your independent professional judgment to your supervisors. So given this 20-second summary of McCurdy, how would you use that rule to protect reporting attorneys who work for private firms?
So if you use independent professional judgment, then it's kind of going to make you don't. It's not as mandatory as you
Well, I mean, the hypothetical involves you exercising your independent professional judgment leads you to believe that you have a reporting obligation. Okay, so you have convinced yourself that you have a duty to report something that you believe to be misconduct, and the firm has gone, fine, you can report that, you're fired. So how do we generate a rule of law from McCurdy that allows us to protect those attorneys who report misconduct? I mean, sure. Why? Okay. How does Weeder get us there? I mean, we're going to have to bring Weeder in from New York, but that's fine. We can do that. But how does it get us there? Okay. All right. We'll come back to you. Mr. Salter, I mean, I think we agree that we're going to be drawing on the Weeder rule to fashion this rule that we're trying to fashion. But what's the justification for implementing this rule to begin with? But why do they need protection? So? So if we allowed this retaliation to happen, it might convince other people not to report misconduct, right? Is that what you're saying? Yeah, I think that's right. So retaliating against reporting attorneys, frustrates the regulatory purpose of the reporting obligation, right? What is the point of requiring you to report if, when you report, you suffer devastating economic consequences, right? And so the only way to prevent that kind of chilling effect is to punish the retaliation. Okay? So thank you, Ms. Carr. Thank you, Mr. Salter. Ms. Akins, now I'm going to ask you sort of the other side, right? So you've been hired to represent the firm who fired a reporting associate. So how are you going to avoid the imposition of the Weeder rule?
I think I would probably just say that I should have the ability to keep which employees that I want to keep.
Mm-hmm.
And yeah, they reported something, but there's some other reason why I'm firing them, or
even if that is the reason, I should be able to hire and fire who I want.
So, but how do you answer the argument that that if we allow you to hire and fire on this basis, right? So we're not going to live in the world where you're going, oh, in fact, it was because you were a low performer, right? Yes, you're probably going to do that as the employer, but like, let's assume that there's a smoking gun piece of evidence. You know, where a partner writes an email to another, we got to fire Joe because he reported Billy for misconduct, right? You know, how do you deal with the argument from plaintiff's counsel that, in fact, the Weeder rule is necessary? Because if we allow your client to just hire and fire as they see fit, then the reporting obligation will become a sham because nobody will report for fear of getting fired.
That's a good question. I guess I don't know if there was incriminating evidence what I would even say that.
I mean, that's reasonable, right? I mean, I think it is reasonable as the defense attorney at this point to go, okay, it's time to get out your checkbook. But let's suppose that the client goes, no, I'm not going to settle, right? What do we do? Ms. Dean, what do we do?
You're kind of a conduit for your client, so either fire your client and move on, or I guess keep going.
Right, but what argument can you make?
Yeah, I can't think of anything other than the.
Okay.
I mean, if you're in an at-will state, employment at will, fired you because you just didn't like you.
I mean, sure, right? But again, if we have this smoking gun email of we got to fire Joe for reporting Billy, then like the we didn't like your haircut argument is not going to carry a whole lot of water. Ms. Yuzi Zuckerman, can you help us out?
Can you go back to the McCurdy explanation?
Sure. Sure. So how do we get past this argument that plaintiff's counsel is offering?
I mean, I guess the only thing I can think of is maybe playing on the knowingly aspect. You can claim that maybe you thought that he knew him, just, I don't know, because he doesn't maybe have the full picture. And I would present it as
Fair enough, right?
his report was not accurate and he had an incomplete understanding of what was going on in the law firm.
I mean, I'm not sure that gets us past this, like, the partner email.
Because he made the report, not because the report is accurate, but because.
Oh, so we're firing you not because you reported us for misconduct, but because you're a jerk who made a false report. All right, it's creative. I'm not sure that I think it may assume facts not in evidence. So let me ask you this, Mr. Guest. What do you say to the spouse of the dead attorney you reported for misconduct? What did you tell us earlier?
I probably wouldn't use the same phrase that you're doing the time.
But this is where I'm going, right? Is that as the defense attorney in this hypothetical, probably your strongest argument is we don't care. Your professional obligations exist regardless of the consequences that you face for them. And as attorneys, we absolutely expect one another to subordinate our economic interests to our professional obligations. And so, yes, we can fire you for reporting, and yes, you still have a reporting obligation. And yes, we can fire you, and then we can report you for discipline for failing to report, right? And this is the rule in Illinois, in case any of you are planning on taking the bar there. Okay. Questions? Yes, Christine.
So to clarify, I guess I missed the part in the hypothetical. So nothing was reported to a formal board or the bar association. It was just like an internal reporting to a supervisor?
I mean, I don't think it matters, right? So whether you're reporting internally and they sort of preemptively fire you, or whether you report it to the committee and they fire you because of that, like, it doesn't matter, right? So, all right, other questions? All right, so the book tells you about Scott Wollis. Wow. But then, like, I don't know if you guys are familiar with the lawsuit that was filed by a couple of associates at Jones Day. But basically, like, some of the allegations are kind of gross of things that Jones Day leadership either did or tolerated or rewarded in terms of the firm culture. And, like, I guess I'm not here to say that these two sets of misconduct are equivalent. I don't know, maybe I am. But Ms. Jackson, like, are we okay? I mean, should we be okay with one or both of these things as a profession? Like, so here's a question, right? Should we tolerate either Wollis's behavior or, assuming that these things are true, what we're seeing about Jones Day? Should we tolerate either of them? No. No. Okay. So what do we do about it? Fair enough. All right. I mean, I think that's a perfectly reasonable answer, right? Because this is like, Ms. Wilbur, what would you have us do?
I mean, the idea of reporting is there.
Okay.
I'd rather report these guys and use my job because I can always find another job.
Yeah, I mean, I don't know that Jones Day attracts a very specific type of lawyer, and that's all I will say about it. So, like, I'm not here to tell you sort of like which of these you should think is worse, because, like, I think I'm kind of with Ms. Jackson that I think both of these lists are pretty despicable. But here's what I can tell you about, like, what has happened, right? The book makes the point that, like, Wollis was disbarred. Whether he would have been disbarred had he showed up to contest and or accept responsibility, because he didn't appear for his disciplinary proceeding. And that'll raise the level of discipline a couple of levels. But in addition to being disbarred, eventually, when they tracked him down, because he disappeared for several years, he was imprisoned. And to my knowledge, the stuff that happened at Jones Day, first of all, the firm has denied all of it. And there's been absolutely no effort to engage in discipline anyone who was involved with that. So, like, Jones Day's defense basically boils down to, sort of the goat defense, right? I don't have a goat. If I have a goat, it didn't escape. If it escaped, it didn't eat your garden. If it ate your garden, it's because you left the gate open. If you didn't leave the gate open, it's because your fence was broken, right? So they're saying, like, none of this stuff happened. But even if it did happen, like, none of it's illegal. And so my question is, like, are we okay with a standard of, like, this isn't illegal for how we conduct ourselves? Like, is that something that we think is an acceptable approach to our professional conduct? Ms. Burton, are you okay with the it's not illegal standard? Why not?
As a law student, I have prescribed to entering into a profession that I know is going to be governed based on other things, such as my morals and character. I think all of us have prescribed to that. And if we're just going off of it's illegal, what are we doing? Why should we have anyone overlooking anything? Why should we report anything?
Yeah, I mean, I don't necessarily have anything else to add to that, right? Like, if the rule is you can do it as long as there's no rule prohibiting it, like, what is the point? Like I might as well just give all of you B pluses and send you on your way. Yeah, right? So I want to shift gears here as we sort of transition towards wrapping up. Ms. Smalley, to talk about malpractice for a minute, would you rather defend a malpractice claim under a tort theory or under a contract theory? A very professorial response.
I think that I would rather do the malpractice.
Well, I mean, fine, but that's not the question I asked you.
Would you rather defend I would rather defend a malpractice claim under a tort theory.
Under a tort theory, okay. So, sorry. The first thing you said was, I'd rather do the malpractice claim. And I was like, I mean, yes, I'd rather be the plaintiff's lawyer as well, but that wasn't the question I asked. So, yeah, under a tort theory. I think that's kind of where I come down. But to sort of give you the complete picture, right, here is what I can sort of off the top of my head say are the pros and cons of each approach, right? And so the reason that I prefer the tort theory is because the proof standard is higher under a tort theory, okay? One of the things that means is that there's actually two steps to the plaintiff's case, because first they have to prove that my client did in fact commit malpractice, and the book kind of talks about the difficulty of that. And then they have to prove that there are damages that are attributable to that malpractice. And what that does is that gives me two hooks to bring down the settlement value of the case, right? Because I can attack the plaintiff's liability theory, and I can also attack their damages, okay? Under a contract theory, right, the contract sort of says what it says. And if the contract is well drafted, sort of ahead of time, then great, the defendant's in a very good position. If it's a badly drafted contract, you may not have very much protection under it at all, right? There's also the issue of like unconscionability and interpreting contractual provisions against their drafter, right? Those issues are still present that are going to create issues. Okay. Let's see. I think this is the last question for today. And Mr. Hall, you get it. So we have a 10 commandments of malpractice. And so my question is, how do we insulate ourselves from these 10 practices?
One way is to be familiar with ways, these, and then also set up like checks within the system to like make sure.
What kinds of checks?
So like other attorneys making sure these aren't going on.
So like providing supervision, right? I think that's right. So some of you may have thought somewhat flippantly that the answer is get insurance. And that's part of the answer. But it's not all of it, because the more of these things you do, the higher your premiums, the higher your deductible, the lower your coverage cap.